Okay, good morning, everyone. It's 9 o'clock. We always like to be punctual, so welcome to our Google Hangout Employment Law series. I'm Lior along with Lumi Punja this morning.
Morning.
And we're here to talk about employment law again and workplace rights and things you need to know, whether you're working, looking for a job, lost your job, if you're an employer or an employee. We want to fill you in on important things. And obviously, anytime you need to reach us afterwards, you can always call us at 416-216-5900. Speak to us. We're approachable. Well, I am Lumi kind of too. No? We'd be happy to talk to you in all seriousness. Now, the topic that we've chosen for today has to do with seniority. And we're going to talk about situations where you're invariably going to have more seniority than you realize. Now, when we're talking about seniority, really matters is actually when you lose your job, because the number of years of service, the number of years of seniority that you have are going to impact how much compensation, how much severance you get. So whether you're a 4-year employee or a 10-year employee can mean the difference between 4 months severance and 14 months severance. So that's a huge deal. And there are circumstances where you actually may have a lot more seniority than you realize. And then when you lose your job, you should know that, because the employer may say, well, you're only a 4-year employee, where in fact, in the eyes of the law, you may be an employee with much longer seniority. So we're going to go through all these, or a few of these circumstances. The best advice, of course, is this. When you lose your job, you have to make sure you get some advice with respect to your severance offer. There's a number of factors that are going into assessing how appropriate it is. There's no linear line of a week's pay per year or 2 weeks pay or 3 or anything like that. It's based on a number of factors, the principle of which is seniority. So let me start briefly in a situation where you may have seniority, a lot more seniority than you realize, and that is if you're in fact working, quote unquote, as an independent contractor. So many times, Lumi and I see this all the time, and our lawyers see this all the time, individuals being engaged as independent contractors, where in the eyes of the law, they're really employees. Remember, the law doesn't care what you call yourself or what someone else calls you. The law is going to assess itself whether you're an employee or contractor. So if you work for a company, regular hours out of their offices for a period of time, you're probably an employee. Doesn't matter how you pay your taxes, doesn't matter what they call you, doesn't matter if you believe that you're on contract. It doesn't matter. You're probably an employee. And how is that important? Well, if that position ends and you've been on contract for 3 years, now you've been terminated as a 3-year employee, so you're going to be owed severance as a 3-year employee. So a lot of people think, well, I'm an independent contractor. I don't have seniority. So if my position comes to an end, I don't get anything. That is wrong, and literally every single day we see this. It doesn't matter what you call yourself. So if you lost your job, doesn't matter as a contractor or otherwise, you have to get advice. Many cases you'll have full seniority. We've seen people that for 20 years have been working as independent contractors, so to speak, and when they were let go, they thought, well, I guess I don't get anything because independent contractor, when in fact they get as much as 2 years severance. So very important, if you're an independent contractor, you may well have more employment seniority than you realize. Now, so that's one. Now let's move on, Lumi. Let's talk about.
I was just going to say on that point that individuals who work may not know that they are employees when they're labeled independent contractors, and companies or employers seem to be just as confused about that distinction. And so we get calls from employer clients, and when they learn that they have, like at law, they have an employee with, let's say, a decade of service, they're very surprised, genuinely surprised, and so there's a lot of confusion on both sides of the relationship. Absolutely,
it happens all the time. Employers think that, hey, as long as you put on a piece of paper that someone is an independent contractor, that's all we need to do. But think about that. If it was that simple, no one would ever be an employee. Why would we ever have employees? Why would I have employees working at my law firm? I would hire all of them as independent contractors. It doesn't work that way. The law is smarter than that, so you may well have seniority even if you don't realize it. Lumi?
I was going to go over a very common scenario where, again, people have more seniority than they realize, and that common scenario goes in the category of inducement. So inducement happens when an employee is actively courted by a company to join their ranks. That happens when, again, inducement happens in the context of someone who already has a job, potentially a secure, well-paying job, and that person is lured to leave that job to join the new company. So that is classic inducement. And in the employment law context, inducement is very relevant when somebody leaves a job of, let's say, 10 years and joins a new company on the basis of promises of a long, secure employment opportunity for advancement, even higher pay. Let's say a few months into the new job, that person loses his or her employment. And so the question becomes, does previous service count or not? And in general, the answer is yes. If active recruitment took place, if the employer or a recruiter on behalf of the employer actively encouraged the employee to leave his or her previous job, then yes, those previous years of service count, and they count in the sense that they lengthen the the reasonable notice period when that employee loses his or her job from the second company. And so, again, the general rule is that the previous service count, and as an employee negotiating the new job, when you leave a long service or long tenure position, as an employee, try to well, don't sign a probationary clause. I think that goes without saying. Don't limit your termination entitlements and by signing a termination clause, and even better, try to negotiate a term that recognizes your previous service with the new company.
Yeah, and that's very important. We see that all the time. If you're recruited from another job and you're let go shortly thereafter, you may have your previous service count towards your seniority. That's very important. And so you always want to be mindful of that. And when you leave a secure job, you want to understand that you're not agreeing to terms, as Lumi said, that are going to be unfavorable to you. Why would you leave a secure job to take a job on probation? So bad idea. Now, moving along with situations where you have more seniority than you realize, and that is if there are gaps in service. So in some situations, you may have worked for a company for a while, left, and came back later, and then down the road you were let go. And the question is, well, how much service do I have? Does all my service count, or just the last stretch of service? Well, in many cases, even though there may be gaps in service, we can almost disregard those gaps and have full credit for the entire length of service. Well, when does that happen? It happens when the overall length of service is significant and the gaps are not. So if you work for a company for 20 years, but in that 20-year period you were gone for a year and a half, well, that's a small gap in reference to the overall length of employment, and it's small enough that we may be able to disregard it. It also is the case when, if you came back after being away, so you left last year and you came back this year, if the employer either explicitly or implicitly recognized your service. Maybe they gave you the same employee number, maybe they gave you the same salary, maybe they waived the probation because they already knew you. So in that situation, they could be deemed to have accepted or recognized your old service. Now when they let you go, they can't say, well, wait a second, employee, you've only worked for us for the last 3 years. Well, no, I also worked for you the previous 10 years, even though I was gone for a year. So in many cases, when there is a gap in service, we can disregard it. Now, if you worked for 2 years, left for 5, and came back for another year, that's going to be a significant gap, and we're not going to be able to disregard that. But the longer the length of service, the shorter the gap, the more it seems likely that the employers implicitly or explicitly recognize that past service, the more likely it is that you have prior service credit, and that could be very, very, very important. We've seen so many cases where an employer lets an employee go believing they're only an employee with a certain number of years, disregarding their prior service, which is absolutely wrong, and which means that the employee has been underpaid. That's a very common situation. So the short answer, the bottom line is if you lost your job and you have previous service that has not been accounted for, again, you need to get some advice because that prior service may well have been or should be part of that equation.
There are even cases where someone, let's say I have a case, an ongoing case where my client worked for a bank for a total of 30 years. And a long time ago, she took 2 years off to raise her kids.
Right.
And so it was a resignation at the time she left, but she was, when she returned, she was treated as a
returning employee.
A returning employee,
yeah.
Not as a new hire.
Right.
And so those years of like that break of 2 years is insignificant in the span of 3 decades of service, and so she will likely get a notice period based on 30 years and not just the last 10.
And that could be the difference between potentially a year severance and 2 year severance. So it's significant, you know, potentially from a dollars and cents standpoint. Certainly, we're talking tens of thousands of dollars here. So again, you don't want to ever be in a situation where, as an employee, you're walking away from legal entitlements that you have without realizing it. That's really what we're talking about here.
Right. The other example is a temporary layoff initiated by the employer, and then the employee is called back to work. Again, that temporary layoff, whether it's weeks or months, counts towards seniority.
Yes.
The other, I guess, broader category that I wanted to bring into the discussion is a sale of business situation. And so when a new company takes over, the seniority, the service with the previous company counts. It doesn't get canceled. And so the seniority is deemed continuous, and the severance, in the event of a termination after the new company takes over, the severance would have to include all the years of service. Also, something to keep in mind, if you sign the contract with company A and then company B purchases the workplace, the contract with company A is not enforceable. And so if company B did not put in place a contract, then the first contract will be disregarded.
Yeah, you know, with the sale of a business, your seniority carries through, but your old employment agreement does not. And by the way, some people may think, "Oh my God, that's awful." Well, no, that's actually a great thing. You'd much rather be employed based on an oral agreement than a written agreement. That means you have full protection of the law. So yes, in the sale of a business, as Lumi said, once the business is sold, if you continue working with the buyer, your seniority carries through automatically, which means that down the road, if you are let go, the new company can't simply account for the years you worked for them. They also have to account for the years you worked with the previous company. And again, some employers may be confused by that, just like they are often with respect to independent contractors and employees. So remember that your seniority doesn't go away, but you also want to be very mindful of what you sign. If you sign an employment agreement, you potentially could sign an employment agreement with a buyer that changes this analysis and disregards. You may sign an agreement that says, we agree not to recognize your past service. And by doing that, if you're let go the next day, you could have potential real problems where now you're considered a new employee. So don't let that happen. Otherwise, seniority carries through.
And sale of business situations are very tricky legally for both employees, especially employees with long service, and companies taking over a business with long service employees. So they're very, very tricky, and you should seek legal advice if a sale of business is pending or imminent. Yes, and
if we move on to kind of our last subtopic today, where you have more seniority than you realize, and that is if you're on a disability leave. So you may be on a disability leave for a while. Sometimes it's a few months. Sometimes it's a few years if you're a long-term disability. And that time that you're on leave counts towards your seniority. So let me give you an example. I've been working for a company for 5 years. Unfortunately, had a serious medical condition. I had to go on a disability leave. I've been on that leave for 2 years now, and I'm ready to return to work. Well, now I'm a 7-year employee. If my employment is terminated now for whatever reason, then I'm a 7-year employee and I have to get severance. I have to be compensated as a 7-year employee, not a 5-year employee. So even though I haven't been actively employed, my seniority counts. So that's very important to remember and understand. If you're on a leave of absence, a medical leave of absence, your seniority carries through. Same thing with a maternity leave. If you've been on 3 maternity leaves in the last 6 years, that's fine. Full seniority counts. You don't lose that time. It's not just the time you spent working. A lot of people think that's otherwise. So that is very, very important when it comes to being let go. You want to understand what your seniority actually is. Now, in some situations, you may be on a leave of absence and your seniority is not going to carry through. So if you've asked for a leave of absence to go travel in Europe, for example, if your employer grants that, then seniority doesn't count automatically. You have to agree with your employer what happens with seniority then. But in certain situations, maternity leave, disability leave, your seniority is automatic. You don't lose seniority. And your employer can say, well, you've only actually physically worked for us for this period of time, and that's all you get. It doesn't work that way. So some examples here that we've talked about, and there's going to be more, but we wanted to give you some of the main ones where you have more seniority than you realize. And again, the fact that you have more seniority doesn't necessarily mean that you can qualify for other entitlements. For example, an employer that says, after 5 years, you get more vacation. It's up to the employer to decide how to administer that. But when it comes to seniority for severance purposes, the law takes care of that for us. The employer doesn't decide how much seniority you have, the law does. So we want to be mindful of that and remember that our seniority doesn't get extinguished. Oftentimes we see employers changing the name. So I used to be XYZ Inc. and tomorrow I'm ABC Inc. Well, if I do that, but I continue to employ my employees, their seniority doesn't get extinguished just because I changed the name of the company. Again, the law is smarter than that. If it was that simple, then employers could certainly take advantage and make sure that people lose seniority and compensation. So that doesn't happen. And again, really, if you're not sure what should be counted, how much seniority you have, give us a call. And I'll give one more plug here. If you did lose your job, you want to get that information. One of the ways to do that, other than calling us, I gave you our number. You can go to the severance calculator, severancepaycalculator.com. Again, severancepaycalculator.com. Find out how much you're owed, get an idea, and compare what you've been offered with what the calculator says. If there's a discrepancy, a deficiency, you need to get some advice. It's an easy tool. It's free to use. It's completely anonymous. And I encourage you to make that the first place you go to if you lose your job. And if you know someone else, if your neighbor, your friend lost their job, don't leave them alone. Tell them about the severance calculator. Make sure that they don't lose entitlements that they're legally owed, like so many people do. And for us, that's it. We will be back in 2 weeks with another discussion about employment law. Happy to take questions. You can always contact us, email us, call us, and use the severance calculator. Thank you, and enjoy the rest of your day.
Have a great day.